One of the arising issues is currently how personal data should be treated in systems that are owned by organizations or outsourced systems which might be holding personal data. And I think the key thing to keep in mind is just that there's a new law called the Protection of Personal Information Act, and there are a number of principles that are embodied in the law which are not in effect yet but will be in effect soon enough, that relate to how one treats the data and how one takes care of the data and the safeguards that need to be present. So one of the overriding principles is that one remains accountable for the data, and irrespective of whether it is your own system or perhaps an email marketing system that you're using where the data is housed, you will always be responsible for how people access the data, use the data, and so on. Another issue is that what you can do with the data is significantly limited. So you will have to process the data for the purpose of collection unless you can show a close link towards any other further processing between the purpose of collection and the intended purpose of using the data. An important aspect is making sure that you have the necessary security safeguards. So how will you keep that information confidential? How will you ensure the integrity of the information, that it remains intact? How will you ensure the quality of the information, that it is actually accurate and you can depend on the information? So that law brings in a number of aspects where one doesn't just interact with the personal data but really has to take care of it. If you have data that you are responsible for which has somehow been compromised, or even if there is a suspected potential breach, the requirement is that you would have to notify the information regulator, which is currently being set up, as well as every other person in that database whose data can be compromised. This in effect gives them the ability to take the necessary steps and safeguard their data. What you want to do is find out what personal data you hold, so what data is really impacted by the legislation. You also want to find out which systems and processes might be impacted. Not everything you do involves personal data, but which are those processes that are impacted. And then you also want to make sure that the safeguards are applied where it's relevant. So where you do interact with personal data and where you do have systems and processes that are impacted. So a typical example would be that if you have a newsletter facility and people submit their email addresses in order to be contacted, then obviously there needs to be some consent for the collection of that information, notification of how you will be using that information, maintaining records and so on for that particular process that you're using. Certain laws require you to appoint an information officer or delegate the authority, at least from the head of the organization, to create a point of contact for requests relating to how data is processed and complaints, and to field complaints, liaise with regulators and so on. So that's a necessary step to empower someone within the organization to have a handle on these issues and be able to deal with them confidently. The other thing that can be done is audit programs or compliance checks and so on to try and understand how far you might be from the requisites of the legislation. So sometimes called a gap analysis, where we look at what the legislation requires and what your current practices are and how to improve the compliance levels. And what you'll find in that is that a number of corporate governance requirements speak to those kinds of programs to make sure that you're boosting compliance, you're keeping compliance on the radar, and that you're doing your best to remove risks of non-compliance.